So I'll call us to order. Thank you. We've got a house full. Thank you, staff, for being here. We really appreciate your time. And thank you, Dr. Crane, for all the work that you and your team went into putting this agenda together. I did want to make a remark about the cell phone policy. There was news, with the start of school, and we know the state law passed, since we did our cell phone policy. But I think we're good until, two things. I think we're good till January 1st, and I don't know that we have any changes to ours that are required. But you can, correct me if I'm, but anyway, that's why it's not on the agenda today, is because it's not,
You definitely don't need to change it until January 1st.
so pressing.
Yeah.
So I just thought I'd make that remark for public that might be watching and any board members that were wondering about that. Do I have a motion from anyone to approve the minutes from June 25th?
So moved.
Second? Okay. I've got Mr. Hershey and Ms. Mahaffey as a second. All in favor?
Aye.
Are there any opposed? Great, thank you. And Dr. Crane, let's get rolling. We only do packed agendas here in policy. Go ahead.
You will notice, yes, we do have a very packed agenda today, and the first, I think, 9 items on the agenda are on the agenda because of necessary updates based on new statutes that went into effect either at the start of this school year or when the vetoes were overridden. And so I'll try to make reference to those session laws and let you know why the update's required, and we'll let you know what that is. We have staff in the room who are going to be at the table. Our attorney is here, and we'll try to delineate for you what the School Board Association has recommended as required or recommended, and what our staff have included. Typically, we do that with a color process, so if you see something in red, that was the School Board Association. If you see it in blue, that was our staff. So, and I'll remind you of that as we move through these. The first item on the agenda is a minor revision, and we have Ms. Kelly Creech here in the audience with us, or here at the table with us. She is our Senior Director of Adult Services in the district and knows these items inside and out. It was Session Law 2025-60 that updated current statute to say emergency epinephrine delivery systems, not just injector devices. So you will see that delivery systems has replaced auto injector devices throughout the policy. There was no change to the legal reference because it was the statute itself that was revised. No additional language and no additional statute was created. So you won't see a change in the legal references there. Ms. Creech, do you have anything to add?
Do not. If there are any questions, I would be glad to.
Any questions, board members? Yeah, sure.
Hi.
Hey.
Good morning, or good afternoon, actually. I just had a quick question in reference to on the policy. Do we have in schools EpiPens for emergency purposes?
We
I know
do. We do. There's a general statute that supports that. So we have auto injectors now through a program called EpiPens for School,
Okay.
which provide 2 junior and 2 adult in each school. They are stored where student emergency medicines are kept in each school.
Okay, thank you.
Anyone else? So I'd like to get a motion to approve these 3, 5024, 6127, 7266. These would go on consent on September 16th. Because if you'll recall, we try to, since we were going straight to consent, we try to give the public a little bit of time to
So moved.
review.
Second.
All right, all in favor, please say aye.
Chair, could you restate, is it just the auto injector? Okay.
But it's
One policy.
3 policies that are referenced.
Okay.
It's one policy with 3, it's a cross-references, I think, to the,
Yeah. It will show up in 3 places in our manual.
it's the same policy, it will be listed in
Okay.
3 separate series.
Yeah, yeah.
All right, sorry, I was confused. Thank you.
Yeah. My apologies. Do we need to restate the motion? Okay, all right. So who are my first and second? Dr. Ing, okay. All in favor?
Aye.
Are there any opposed? Thank you. 4100?
We'll pause just a moment, let Ms. Boyd join us here
Yep.
at the table. This policy required a revision due to Section Law 2025-72. The revisions are found on pages 7 and 8. And again, this was a revision of existing statute, so there was no change in the legal references. And on page 7 and 8, I'll let Ms. Boyd, will you walk through the revisions for us?
So you may be familiar with the military compact, and so they had some updates to it that were a little bit more permissive for our families, such that they could use this privilege not only if they're coming on transfer, but if they're retiring, and it's their first year of retirement. So that's what you're seeing in Section 1 or E1. In E2, it asks what it is that we would use to support that they qualify for this particular permission or privilege, I guess, if you will. E3 lets us have a little bit more flexibility in the proof of residency. It used to be that some version of proof of residency needed to be provided in order to begin enrollment processes. This would absolve them of that in the initial uptake. We have to get something at some point, but we could go ahead and start the enrollment process. So if they wanted to apply for magnet or calendar application or anything like that during those application periods, we could go ahead and move forward as long as we have the other requisite documents, which is something no other family would be allowed to do. We'd have to have proof of residence to verify that they're domiciled in Wake. This would give them a special permission to do that. Section 4, or E4, excuse me, is new then, and it allows that, in addition to having that flexibility to not put the proof of residency in during the time of pre-enrollment, they also could use an anticipated domicile to establish their eligibility in Wake County schools. So that would mean that if all they have is a temporary residence, it's okay. We could use that to allow them to enroll while they're waiting to maybe close on a house, find permanent housing, maybe they're still working with the realtor. So if they had only, let's say, an Airbnb, or we're staying with friends, that would all be okay for us to establish their eligibility to enroll in the district. And that's all we're considering in this policy, is just the eligibility to enroll in the district. And then finally, there was, and if you read through that section, that because of the unique nature of our families going through these times of transfer and transition, if the student was an older student, starting either their junior or senior year, they'd be permitted to stay through the end of their senior year regardless of what happens with the residency status over time. So the student could have that stability for those final 2 years. I think that was all of the... That's the gist of it, and Neil might have one more.
I do.
note.
Just a couple of technical changes. I had a call with the lawyer for the General Assembly about this. There's actually a typographic error in the statute that was reflected in the NCSB revision that we were presenting, so I think we can correct it. It's consistent with the intent, and I was told that the General Assembly will eventually correct it as a technical correction on their end. It won't change the way anything Ms. Pulliam just described, but it's in the numbering in this new language towards the end of Section E, Section E4. You see where it says that students, let's see, if the proof of residency has not yet become available when the parent or guardian are residing in temporary housing, the student will be permitted to enroll and begin attending school based on anticipated domicile. Then it has a colon and there's a numbered list. What we need to do to fix this is delete well, I'll just tell you how it should read, and then we can make the corrections. It should read, the student will be permitted to enroll and begin attending school based on the anticipated domicile, colon, A, for a period of up to 1 year from the parent or legal guardian's reporting for duty, care, separation date from active military duty, or anticipated separation date from active military duty, B, through the end of the school year, or C, through high school graduation for a student who is enrolling as a high school junior or senior. And then I suggest also adding at the very end, comma, whichever is longer, because that's not expressly stated in the law, but it's clear if, for example, if you have a new student who's coming in as a junior, I think it's pretty clear the intent is that that student should be allowed to attend school through high school, not just for 1 year. So I think whichever is longer is implicit. But that's, again, just, everything I said other than whichever is longer is just a technical correction that will be reflected in the statute as well.
Anybody have any questions about that, what Mr. Ramey just described, that section? Okay. And are there any questions about this policy in general, 4100?
I'm sorry, I forgot. I have one more.
Go ahead.
I have one more suggestion. This one is not a technical correction. There's nothing wrong with the policy as currently stated. But Ms. Pulliam and I are going to be working on possibly some updates to policy 4150 for a future policy committee discussion.
Okay.
And in anticipation of that, I thought it might be helpful to add something at the very end of E here that would note that everything that we've just summarized is about admission to the school system as a whole. It's not about which school in the district the student attends. That we're going to update in policy 4150. And to make that clarification, we could just add, this policy governs admission to the Wake County Public School System, not enrollment in particular schools. For information about assignment to specific schools, please consult policy 4150.
Dr. Crane, did you catch that sentence that Neil just, and that's going to be added at the very end of section E, right? In that conclusion
Yes.
paragraph or section E?
Yes.
Okay. Mr. Hershey?
So when they don't have proof of residency yet and they're seeking to go into a specific school, are we saying that they can't, they're basically, are we,
That's what we've got to work through, is what the intent of the legislation is, which is why we're not bringing 4150 today.
Okay.
There's some, we have clarifying questions about the intent and that we need to work through with the legislative officials to understand, did they intend that if they perhaps had a temporary residence in a different county, but anticipated living in Wake, that we should enroll? Or did we at least have to have the temporary residence within Wake before we could get started? And then the normal policies would apply usually for the school assignment from that point forward, but we do have some very specific questions to make sure we're supporting the families as intended.
because the follow-up is if they are not in the county and then they pick Wake Forest, because I have a Wake Forest company.
And that's
And then
not-
they move to
Yes.
Cary, is the law then making it so they stay in Wake Forest?
Excellent
Well,
point.
the law, the quick answer is the law doesn't address which school the child attends. It's basically, the purpose is it recognizes military families are somewhat transient, and they need to get started and enrolled before they actually move into the school district. So it's really about admission to Wake County schools. It doesn't tell you which school to attend. We still need to circle up and sort out what's that going to mean. There's some tricky questions there, but you're compliant with the statute if you just adopt these revisions or follow these procedures, because they don't really address which
And Neil,
school.
would it be appropriate to say this doesn't absolve them of their authority to assign students?
That's right, and I confirmed that with the lawyer for the General
Thank you
Assembly.
so
There was
much.
no intent to override your authority to assign students, manage transfer process, et cetera.
Thank you.
Okay, and would you please read that sentence that you want to add one more time, please?
Yes, absolutely. It would be, This policy governs admission to the Wake County Public School System, comma, not enrollment in particular schools, period. For information about assignment to specific schools, please consult policy 4150.
Great, thank you. Yes, Dr. Green?
Just curious, does it speak to some of the circumstances where people who are living on the edge of the county or outside of the Wake County, just on the edge, and they, would wish to still go to Wake County school, but they live outside of Wake County school? Is that,
I don't believe so. It's the anticipated domicile would be within the school district.
Right.
So the anticipated domicile would have to be identified as being within Wake
within
County.
Wake County?
Right, and the presumption is they're eventually going to move in the county, but it's a military family in transition. They may be in temporary housing outside of the county lines, or just somewhere temporary. Normally, temporary residence is not enough to establish eligibility to attend your school district, but for the military families, by statute, it is. And the policy breaks it down how much time the family, the grace period, this could be up to a year, it could be until for juniors and seniors until they graduate, before they would have to establish permanent housing in the district.
Okay.
Chair Haggerty?
So just to make sure that I understand this correctly, the changes are all confined to Section E, so they're only in regards to military families.
Correct.
And then with the sentence that you're adding, because it's talking about enrollment of students in the district, if a family was already in the district but anticipated a move someplace else within the district, they wouldn't be able to take advantage of this flexibility. They'd still have to follow the existing policy.
Correct.
Okay, thank you.
Okay. Anyone else? All right. Is there a motion to move 4100 to consent for the September 16th meeting?
Second.
That's with the additional changes?
Yes, I'm sorry, yes.
Sure that that's reflected.
Yes.
With,
Motion.
yeah,
To do so.
And second.
all right. All in favor, please say aye.
Aye.
Are there any opposed? Great, thank you. 5070, public records, retention, release, and disposition. Good afternoon.
I'd like to do the items in this section in two parts as far as motions and et cetera.
Okay.
The first part is policy 5070, 7350, public records, retention, release, and disposition. The revisions are on page 1 and 2. These were spelled out in session law 2025-73. And you'll see some additional revisions in the legal references on pages 3 and 4 also. So we have, do you want to walk through these, or do you want me to walk through?
Either way.
Okay. So the two revisions that we've had is one addition on page 1 regarding any report received from the Teachers and State Employee Retirement System pursuant to General Statute 135-8 is not a public record and will be treated as confidential. And then on page 2, in item number 7, to add greater specificity and some additional items to what is public record in an employee personnel file, number 7 includes total compensation from all funding sources, including at least salary, adds the word supplements in the what that includes, and also adds and reimbursements and allowances, including travel-related reimbursements and allowances. And then number 8, the date and amount of each increase or decrease in total compensation with the board. So along with those revisions and the legal references, those are the legally required revisions for policy 57 and 7350.
Okay, and you want that as its own motion? You'd prefer it that way?
I would prefer it that way because the next two are kind of paired together around the same item, same topic, if you will.
Okay.
Motion to approve consent
I was going to do that.
All right, that was...
No, please. That's
That
your
was,
day.
yeah, that was Ms. Mahaffey made the motion and Mr. Hershey seconded. And that's just to adopt the changes on consent that are on pages 1 and 2.
And in the legal references.
Yes, and in the legal references. Is that the proper way to state that?
Yes.
Okay. Any questions? All in favor, please say aye. Aye. Are there any opposed? Okay. Part two?
Part two, the next section is, and I'll invite Nathan and Trish, if one of you would like to come to the table here, just to have our backup here, require a change in policy 7100 on pages 2, 3, and 4, and the legal references. This has to do, both of these policies have to do with Session Law 2025-47 and criminal records checks for contract employees. So in policy 7100, the revision on page 2 is to add some headers, create a numbered list about reporting arrest charges and convictions, criminal history and sex offender registry checks for candidates for employment, then adds new item number 3 on page 3, criminal history and sex offender registry checks for contractors, and then adds a new item, header 4, exclusion from hiring based on criminal conduct. We also struck at the very end of that section that the School Board Association did a section that is basically moved into the front of item number 3. So this language talks about each contract executed by the board with an independent contractor or for services of independent contractors must require the contractor to check sex offender registries as specified in policy 5022. We also added all independent contractors are employees of independent contractors who carry out duties customarily performed by school personnel who have significant access to students are, pardon the typo there, are also required to undergo a criminal history check. Additionally, any individual contracted under General Statute 115C-253 to provide transportation services to students must also undergo a criminal history check before acting as a driver under the contract. The terms of the transportation services contract may require the individual to pay for the cost of the criminal history check. What our staff struck is what is allowed in the statute, and that is that a new criminal history check won't be required if the board receives the results of a criminal history check performed on the individual by another North Carolina school system within the past 3 years in accordance with the requirements of General Statute 115C-332K. Our staff does not use criminal records checks from other systems, regardless of how old they are, correct?
Correct.
Nor do we recommend, nor does our staff recommend that we do, which is why you see this language in blue struck that was included in the statute. We do not do that, and you'll also see other changes in there. Do you have any questions for our staff regarding that? Sure, absolutely.
Can we have to make suggestions on this?
Yes, absolutely.
All right.
Yeah, please.
May I speak?
Yes, please.
As far as on number 3 in the blue section where it says all independent contractors or employees of independent contractors, I think the term should be and. Because if you say or, they're going to be battling out who that's who's responsible for it. So I think the contractor and their employees of contractors. The other suggestion I had was where it says down below next to the section that we struck out, the terms of the transportation services contract may require the individual to pay for it. My suggestion would be shall, because may should be the exception.
That if you say shall, then there's no exceptions. I think may preserves flexibility, and I think there are a variety of approaches in contracts I've seen, so I'm not sure that, the board could say shall, but then that's going to mean all contracts will have to comply with the policy, and we have to ship those costs to contractors, which could mean that is just...
That's good.
It is.
That's a good argument.
Yeah.
And the only other thing I would suggest is if we had language that says the contractor must report new employees after the contract is in order. Because what will happen is they'll give us a registry at the very beginning, a sexual registry at the very beginning, and if they get new employees, we don't know about it until they've done something wrong. God forbid. But,
Where is that? Where are you talking about?
well, it's not on there.
Oh, okay, so.
I would say it, under the header in red, it says the contractor must require.
Are you still under section 3?
Yes, ma'am. Under the very top part, where they struck out the word "be" in board, or under that, I would suggest that the contractor has to give us an updated list as they bring on new employees. Otherwise, we don't know about it.
So that could be addressed in policy. I'll just chime in on that. That's also could be handled just as a matter of practice by
Okay.
staff. I'm not sure, if that's something we would want others to weigh in on, just because I think there might be different approaches and different contexts to that issue that I've seen in reviewing contracts. So I don't know, I'll leave it up to you. We could put that in policy now, but then it would be locked in for everybody without, a chance to vet that with other staff.
I just have one, I'm sorry. I just have one more point. The word significant. That's a broad, significant. I mean, someone could say, that person doesn't have it because we don't have significant. Well, where are you defining that? I would think. In the blue. It's significant is actually the word we want to use. Because that gives plaintiff counsel a big, broad brush to work with.
So maybe just have access.
Yes, ma'am. Or access alone. I mean, that's what we usually go by, access alone. I'm sorry, we talking amongst ourselves.
No. Chair Haggerty.
All right. If we're going to probe more deeply into the language, we need to make sure everybody understands all of the language. So let's go to this section 3, to this first section that was pointed out. It says, each contract executed by the board must require the contractor to check sex offender registries as specified under policy 5022. Can you brief us on what is required under policy 5022?
Yeah, I did print it. Basically, it only required the sexual background check. It was not requiring a criminal background check. You have a copy of it? I read it this morning, and I don't have it with me, sorry.
115C332?
Policy 50.
Oh, you're right, we're talking about the policy reference. Okay.
Yeah, of course.
Yeah, that's the
Oh,
section.
come on. I will.
So yes, that first sentence is a cross-reference to your sex offender registry check policy. The next sentence talks about criminal background checks.
So in reference to those policies, does it specify frequency or duration or how often these checks must be conducted by the contractor or by the contractor?
Annual checks.
Annual?
No, I'm saying in 5022, it says if the district contracts with an outside person or entity to perform a job on a school campus or at a school-sponsored program, the contract must require the provider to conduct annual checks of contract.
Yes, it's annual.
Okay. So that's the distinction that we're talking about. If you're saying of all employees, and if another section says we're doing it annually, what could have changed within that 1 year's time? And then, depending on the size of the contractor, are they doing this every time they add a new employee? Or is it on like a certain more regular basis? Or what's an appropriate requirement? Like, if it's a small operation, they've got 4 employees, I think it'd be pretty simple to do. But, if it's, a very, very large organization, I don't think that employs thousands. I don't know what frequency we could expect, if that would be obstacle in some contracting or some agreements with some larger vendors.
Well, I guess that's where we have to define what, if we want to use significant or just access to all employees.
access to all students. The differentiator in the sexual offender check says that checks are not required for individuals who are solely delivering or picking up equipment, materials, or supplies at the administrative office or loading dock of the school, at non-school sites, at schools closed for renovation, or at schools' construction sites. So that is the exception in our sex offender category.
And everyone hears that and gets the distinctions.
So sex offenders can come onto the
Property, Dr. Crane, that's referenced in 5022.
That is directly from 5022.
So to clarify that a sex offender could come on in those certain circumstances.
They're prohibited by law from being on school property except for with narrow exceptions when students are present, and your policy prohibits it as well. So the checks are for contractual personnel go beyond the legal prohibition. It's already a violation. It's a crime for a sex offender to come onto a school property. The checks is an additional safeguard.
Those are my questions.
Okay. Did you have anything?
Yes, what Neil just mentioned is in the first part of the policy on sex offenders, registered sex offenders. It says, accordingly, any registered sex offender is barred from school buildings, school facilities, school campuses, or other school property owned, leased, or maintained by the district, or from attending a school-sponsored event.
Only exception would be like the parents when they're
Except-
supervised.
Except as provided in this policy.
Yeah, there's some
And
narrow exceptions.
the exceptions have to do with a parent or guardian of a student.
And voting, right? For people coming on to vote, sex offenders coming to vote
Yes.
in schools as well.
So I wanted to make sure that I understood, and I'm sorry, remind me of your name. I know who you are, I know what your role is, but
Nathan.
Nathan, are you saying that when our contractors bring on a new employee that we hire, that we're not doing background checks? I hope I'm misunderstanding what you're saying.
We are supposed to be doing, yes.
Every contract I've seen is either required that the contractor certify that they've done the checks, and they submit a form that says they've done so, or they submit, more commonly, they submit the information for the school system to run background checks through HR. And that's the approach that I think is almost always used when the contractors are working directly with students in close proximity. There may be other cases where the contractor comes on school property, but just to do some exterior construction work or something, and I think in those cases, they may certify, the company may certify that they've done the CBCs. They're both acceptable by law, and I'm not comfortable speaking universally for the district because we have so many departments, but I think those are the legal options, and I think they're both used in some context.
I'm just trying to consider the addition that you're suggesting with what our practices are.
It sounds like the question, let me clarify, the question you're asking is, do our contracts require the folks we contract with, independent contractors, or for the services or for whatever, do we require them to continually update the list of?
We don't. Contracts that I've seen has not, there's provisions sometimes that, if we renew a contract, we'll ask them to do it. But I don't see where we're getting them automatically.
Got it.
Because you could have someone who passed today and tomorrow did something wrong, and we would never know about it.
Well,
Or until they did something wrong again.
right, I mean, that applies across the board. Okay. Ms. Caulfield?
I had a question in reference to the, how often we require it. I know in another part of the policy, it talks about 5 years. But when parents come in and they sign up to volunteer, it's every year. You have to do that. Do we require that with the contractors every year for them to do this?
I haven't seen that.
So can we add verbiage in there that is?
Well, it just says that we're supposed to do it based on 50-22, which would be annually.
Yeah.
Right, but on this particular policy, when we're talking about it, it doesn't say by year, but there was another part that it actually talked about statute. It said 5 years.
Contractor time.
So I think, Mr. Amy, I'd like I think we're blurring 7100 and 5022. And if you could
Yeah.
help us,
Yeah, there's a cross-reference here to the sex offender registry check requirement, which is in policy 5022.
Right.
But that's not, that first sentence, that's all it does is basically flags the issue, refers to the other separate policy. The rest of this section is about criminal background checks for contractors. And to the extent that there, one thing I would just suggest maybe is if there's an interest in revisiting this was vetted, for presentation by multiple departments. If there's interest in revisiting it, might be good to, I don't believe there's a statutory deadline here. We could send it back for further review by staff, just to make sure we're, consulting with folks in various departments who would play a role in this. In particular, HR, who runs the checks, and I can't speak to the cost of the background checks, for, frequency of, et cetera. It might be good to bring it back for further review.
Ms. Rice?
I just had a general question, possibly, since this is the topic, and we're concerned about whether or not it's happening, I'm assuming. We're concerned about what's happening or preventing what's happening. In reference to 5022 and the conversation around we're allowing people onto properties that are sexual offenders or are not doing a criminal background check, is it something in practice that we're seeing as being a challenge or a problem? And I don't know, we have our superintendent of HR here, if it's something that he has noticed, that people, when it's time for them to redo checks for whatever reason that they have to, is it something that we're generally seeing as a challenge? That's the question. So I'm trying to determine, are we trying to mitigate or are we trying to prevent?
Yeah, I think Ms. Rice, good question. We're not seeing challenges in terms of running the background checks. We are running background checks for contractors. I think it's just making sure that the language in the policy is speaking to that.
I've not heard of that. So to be clear, sex offenders are not allowed on school property except within the parameters of both your statute and your policy, which is parents who are registered sex offenders who have to be supervised for the entire time they're on school property.
Yeah, I'm
or
aware
voters
of that.
who come to vote in a precinct, and again, it's supervised setting. But I've not heard of any specific concern about this. Something I can tell you, every single contract that I review for your district has sex offender registry checks and criminal background checks, and I've not seen that missed ever. How it's addressed may vary depending on the project and the extent to which the contractor has contact with students or is in proximity to students, but there's always some requirement that meets the legal policy requirements.
So I'm assuming our staff is just really asking, can we just change it from the annual to how often are you desiring for it to be checked? Because that's what it looks like. I think that we're here. If it's done more than annually, based on current policy, what is your suggestion of how often do we want it checked? Because I don't know, I might be stretching. I know we can't check staff or contractors' records every day. So, because to the point of you can do something today and maybe not tomorrow. So I'm saying, what is feasible, or what would a reasonable person assume to be that's a checks and balance of often? Outside, I think I don't know if it's necessary to do it beyond every year, but I am in agreement with putting in language that vendors should update their registry with us as they hire on new people, if that's not in our policy.
I think we should bring 7100 back. If we're not under a deadline, that we should bring that back with 5022 and do them together, just so the board can have, the discussion that's warranted. Chair Haggerty, did you have something?
No, I think your motion will take care of my concerns.
Oh, sure. Hey,
Yeah,
Mr.
and
Mayor.
I was going to echo, Ms. Edmonds, what you suggested, perhaps we can regroup. I'd like to even discuss with your attorney why this one section is even in this policy, because it seems if the policy is related to recruitment and selection of personnel, that is a wholly different topic than background checks on contractors. And so I think we can do some work behind the scenes, and if the board is open to it, we can come back in a better sense.
Okay. Do we need a motion to table that, to bring it back? I don't think we do. Okay, all right.
You could just move along, but it's be appropriate to have a motion to bring it back. That's fine,
You
either
would
way.
prefer one?
If you don't take action on it, we can just put it back on the agenda for future meeting.
Yeah.
But if you want to specifically take action to bring it back for next meeting or some future meeting, you certainly can.
When we bring it back, can we consider the 4 things that Nathan suggested? Because I think they were pretty good suggestions. They have more concrete expectations rather than suggestive. So-
Well, yes, my expectation is that you all will huddle up with your team, with you and your team, to get a little more clarity for us on what you're looking for, and to give us some more, materials to reference, and
We will.
so let's do that. All right, Dr. Crane, can we move to 6340?
Absolutely. This policy is also revised on page 1 as well as page 3. Page 3 is the legal reference. Page 1 simply adds in the statement that says, before acting as a driver pursuant to a contract under 115C-253, an individual must submit to a criminal history check as described in Policy 7100, Recruitment and Selection of Personnel. This is why these two came together, because one referenced the other, and the reference checks for, or criminal record checks for contracted personnel being in Policy 7100. We may need to go ahead and pull this one.
Yeah.
If we don't know if we're bringing that one, leaving that language in Policy 7100 or no.
Yeah, just the 3 of them.
Okay.
And board members, I'll certainly discuss this when we develop the agenda for September with Dr. Robinson and Dr. Crane, so. All right. Did you have another question?
I did, because this kind of follows into item number D, where it says criminal history check and child providers. That's where the language, that's why I was getting confused between some things that were written into some of the attachments, because it does say every 5 years. So I wanted to ask the board if they were comfortable with that being every 5 years.
And you're
Especially-
looking at Section D in
Section D.
6340?
Yep, underneath 1 and 2, the first sentence before beginning initial employment or volunteer service at the end, and at least every 5 years thereafter. That was a little bit long. I was worried about, like,
I think you're on, are you on,
page 4.
yeah, but what policy?
Are we still on 7100? No, I'm sorry, I was writing notes. Okay.
That's okay.
7100, page 4, section D, criminal
Right.
history checks of child care providers.
That's why I say we need to revisit these. All right, let's move on to 1310 and 4002.
These two policies have a similar revision. Both these revisions are required by Session Law 2025-84. They are revised in the policy as well as a legal reference. Policy 1310 is, the revision is found on page 11. There's a new item number 12. Under the list, in Section D, which is a list of activities that require written parental permission. Item 12 has been added, and it says, students sharing sleeping quarters with a member of the other biological sex during any activity or event authorized by the school, unless the member of the other biological sex is the student's immediate family member. And there's also a reference there to policy 3320. We struck the reference to policy 3620, extracurricular activities and student organizations, because we have not adopted that policy. The policy doesn't exist, so we struck that. In policy 3320, you will find the revision on page 2. Students are prohibited from sharing sleeping quarters with anyone of the other biological sex as defined in General Statute 12-3.3 during a school trip, unless the member of the other biological sex is the student's immediate family member, for example, a parent, sibling, or grandparent, including step or half relationships, or, second exception, the parents of all students sharing the sleeping quarters have provided written permission to the school.
So this comes from the same statute, right?
Correct.
And why the different wording? Any explanation or just?
I think
for
that in policy 1310, this is just a list of activities that require parental permission. And in policy 3320, this is the section is titled parental notice and consent. And it's just phrased with are prohibited unless this. So
Thank you.
one is part of a list and the other is a more full explanation.
All right. Any questions? Okay. So can I get a motion for 1310 and 3320 to go to consent on September 16th? Moved. Second. That was Ms. Caulfield and Ms. Gordon. All in favor?
Aye.
Any opposed? Thank you. 3210.
We'll have some more folks join us at the table. Three folks joined us in the last item. We have Allison Reed and Kendra Allen, who are joining us now to move through these. I want to address first a question that Mr. Hershey had asked regarding the language where parent guardian has been struck out throughout the entire policy. The word guardian / guardian was struck. That is not a required revision. The School Board Association added a section in the very front of the policy regarding, for the purposes of this policy, all reference to parents include, and gave a list. Parent, legal guardian, a legal custodian, or another adult caregiver, or caregiver adult authorized to enroll a student under policy 4100. Chatted with Neil here, and he has suggested that we can keep parent / guardian. The only thing we will need to do is to change the item that's in quotation marks that you see in red. So we can say that for the purposes of this policy, all references to, quote, parent / guardian, end quote, include, et cetera.
Yep. Go ahead, Mr. Hershey.
This point was raised by members of the community, and this is, we had a policy earlier today where it said parent or guardian, so it keeps our policy consistent to have parent, guardian.
I agree. I think it really honors the spirit in which we want to honor guardians as much as parents, so I prefer that we do it that way.
So that's the first
Yep.
set of the revision. The remainder of the revisions are found in page 6. And for the purpose of clarity, we want to also suggest that we add a numbered item 3 before the language that was added. And the numbered item will read, parent restrictions on student access to school library books. To make it clear that what this section addresses is access to school library books. And parents being able to restrict that, not any other type of material.
for assigned readings, for example. It's not parents, tracks the new statutory requirement that it applies to books that a student would check out of their own volition from a school library or classroom library. This law and this policy change do not address opt-outs for assigned curricular materials. There's another policy that we'll get to that does, but this statute is more limited. It basically says parents can select any book in the library that their child's not allowed to sign out, and the school has to honor that request. Same applies to classroom libraries.
Dr. Crane, can you repeat you want to insert a header for number 3, and it
Number item
reads?
3, parent restrictions on student access to school library books. May I read what that language is, Mr. Hershey, before we take your question, or you want the question before?
No, go ahead.
So the material inserted, again, in red and in blue, and red from the School Board Association, in blue as recommended by our staff. In red, any request by a student's parent that the student be prohibited from borrowing certain library books will automatically be granted. For purposes of this policy, library books are defined as all instructional materials other than textbooks that are available at a school, whether in a school library or in a classroom or other space, for independent use by students and school personnel outside of the standard course of study for any grade or course. The titles of all library books at a school may be accessed through a searchable web-based catalog displayed on the homepage of the school's website. Our staff added, to request that a book in the school library collection be prohibited for a student, the parent must use the parent portal in the library management software system to identify the library book or books that the student may not borrow. To request that a book in a classroom library be prohibited for a student, the parent must submit the request in writing to the principal and applicable teachers, and must identify the specific book that the student may not borrow by title, author, and ISBN. And we have with us our senior director, oh gosh, I'm going to get all of the titles wrong, Digital Learning Libraries, and our director of library media services to answer any questions about this, as well, and Drew Cook with academics, not to overlook Andrew.
Yeah, go ahead.
Just very quickly, so in red, that's directly from the state law?
NCSBA, but it tracks the statutory requirement, yes. There's not much wiggle room in the red.
Because I was asking, it was because we say library books are defined as all instructional materials.
We did have some discussion about that. The word "all" is not in the statute. That could be removed, but the rest of it is pretty much the statutory definition. And that's not a bad, that was raised in our internal discussions. We talked about actually removing the word "all" just because it's not in the statute, and it may be a little more definitive than you need to be.
Yeah.
It seems like we're being very, I'll let the word speak for itself. I think it's too much. I would take it out.
Dr. Ng, did I see you? Yeah, go ahead.
Do we decide on whether we're going to use parent/guardian or just parent? I didn't get what the...
Sure, we are going to stick with parent/guardian, and in that very top of the page, the red sentence will now say, quote, parent/guardian, so that it's consistent throughout.
Okay, because that additional language in the red and blue does only say parents, so I just want to be...
That will be updated as well.
Updated, okay. And then just a question regarding the web-based catalog, searchable web-based catalog. What is the status of that?
So the system that we use currently to manage our library collection is called Follett Destiny, and so all of those catalogs are available to the public right now. There will be a link that will be added that will give parents directions for how they log in with their credentials that are aligned to Infinite Campus to identify that they are in fact a deciding parent or guardian for a student, and then they can go through the catalog and mark titles for which they do not want their child to be allowed to check them out.
It's actually there.
Perfect.
It's already up.
Look at us. We're ahead
Lisa
of the
Lucan is,
Yes, it is
it's
already
lightning
there.
fast.
And so they will just indicate through that link what they do or what they do not want their child to be able to check out. And then if the child is in the library, that will pop up that will say you're not allowed to check this one out. and we are,
So as soon as the attempt to check out a book, it'll pop up
and
at that
deny
point?
access to check it out. Yes, sir.
Gotcha. Okay, thank you.
Sure. Thank you. In the blue paragraph on page 6, where you said we added 2 paragraphs, one of those, the first one says that the parent has to use the parent portal in the library management system. They go through Infinite Campus for that?
No, they go to the link on the school site for the library collection. And there's a link on the library collection that says, click here to select books you don't want your child to check out. We've updated that.
Okay,
those
so they
sites.
do have to like have a login and sign in?
It's just their email, but they confirm the email through.
Correct. So the emails are already provisioned into the Destiny system from Infinite Campus. So it's already been in place for years in that compatibility between the SIS and our library catalog system. Those parent email addresses that are mapped over, the system recognizes. And so what they'll do, they'll go to the link, they'll put in one of those parent email addresses that are already mapped out of Infinite Campus, and the system recognizes it. It will send them an access code to that email account. They will use that access code as their additional factor of verification, and that will then recognize them as the parent. When they go into that portal, they'll be able to see any of their children enrolled in the Wake County Public School System in each of those child's individual schools. So they'll be able to handle the whole family, in theory, in one access point.
Okay, so similar to us with the Duo access code, it sends you like a text to confirm
Correct,
it.
yeah. It'll send an authentic, a code to that email account that was registered with the school system.
Okay, thank you.
The cross-referencing between the systems is just how we authenticate the parent.
So this is live, and right now, if any board members care to check it out, it's currently on the very bottom. If you go to the WCPSS homepage, you'll see a link at the bottom, the school library catalogs, that Lisa Luton was able to get that up very quickly because the law went into effect without much notice. I think it may be put in a prettier location at some point in the future, but it's there now.
Yes.
Thank you, Ms. Edmonds. I did want to go back to the point Mr. Hershey had raised. When we talk about all material, it seems like for what they're talking about, it would make more sense if it was all printed material or all written material, or things that might actually be checked out, or you disagree?
The statute is inclusive of non-print material.
Yep.
Okay. All right, well, in that case, you have described kind of how the current system would work for books that are checked out. And this is something that we already have in place now, is that
We
right?
activated it in the past week, yes, sir.
But this is only for someone this monitoring only works when someone is in the act of formally checking out a book through the checkout process. Is that right? Okay. Because I just didn't know how we would enforce this if someone was browsing a book in a library or reading during silent reading time
Or stole a book.
yeah.
You really can't, and you don't need to under the statute, because the statute just applies to borrowing the book. So it's only if the parent can say, my child's not allowed to borrow, meaning take it out of the library.
But you feel you can comply with the law based on the system you have in place?
We do.
Thank you.
Mr. Cook?
On that point, Mr. Haggerty, I do want to clarify that there is a little bit more work that's going to be involved with the classroom library piece. So when you ask the question, we're talking about a pre-existing database that I think pretty quickly, obviously, is already up and running and can be modified accordingly. There's a little bit more work. We believe we've identified a platform where we can quickly upload all the titles in there, but obviously we're talking about individual classroom collections across the entire district. And so that's going to require a little bit of upfront work that we're in the process of kind of creating a step-by-step process for what it looks like for teachers, for schools, so that that database will also meet the need to be digitally searchable and essentially follow the same process if a parent wishes to identify a text or book that's in the classroom that they don't want their child to read.
And Mr. Cook, just ballpark for us, how many classrooms do you have, would you say that we have in Wake County Public Schools?
10,000, give or take.
Thank you. Yes, Ms. Wood? Did you want to follow up? Sorry.
Oh, just that I'd thought that it would be a little more complicated than we have the system in place and it's ready to go, so I appreciate that clarification.
It is
Cost of
doable.
materials.
It is
It's
doable.
doable, but it will take some work. Okay.
Classroom, it's going to be a little
Sorry,
heavier to
sorry.
lift.
No worries. Yeah, Ms. Gordon. Yeah, I want to go back to Mr. Hershey's comment as well around the wording of all instructional materials. In the spirit of respecting our educators' professional expertise and instructional materials that they do choose for their classroom, given their professional background. Instructional materials could be visual aids such as charts, graphs, videos, digital resources, including educational apps and websites. So I would be inclined to also take out all.
That would be fine. Again, the word "all" is not in the statute. I think otherwise the definition is very similar. You don't need to say "all." That's just a point of emphasis, honestly, in here. So no problem if you.
But it could be interpreted.
That's a good point.
Right.
Right. There may be some particular material none of us can think of right now, some example that a close analysis would say doesn't meet the statutory definition, but having the word "all" would suggest it does. So I have no problem with removing that word. Prefer.
Ms. Mahaffey, did you or Ms. Rice have anything?
No, I agree with striking all.
All right. Yes, Mr. Hershey.
I just want to appreciate Dr. Inning pointing out that we did say any request by a student's parent, and then put the /guardian.
Yes.
Thank you.
That will go in the title as well, the header title, number 3, parent/guardian restrictions.
Anyone else? All right, so can I get a motion to put 3210 on the consent agenda for September 16th with the parent-guardian changes and striking the word "all" in, let me get to the right section. Section 2, well, I guess it'll be under the new Section 3 in the red part.
So moved.
Second. All right, that's Mr. Hershey and Ms. Caulfield. All in favor, please say aye.
Aye.
Any opposed? Thank you.
Next on the agenda is a new policy for the district. Not that it's not something our staff don't manage, haven't already been managing anyway, but Session Law 2025-84 states that we are required to adopt policies on religious-based exemptions from schools, school programs. This policy doesn't have any breakout sections. In further review, we have a couple other revisions to this. Again, we've had these in hand for not 10 working days, and we opened our new school year as well. So we have kept looking and reviewing the policy, so I want to walk you through it section by section.
Okay.
So in the beginning of the policy, it speaks first about a curriculum being based on current statewide instructional standards, and that our board and school administrators will exercise their authority to select appropriate materials and teach the curriculum in an effective manner. The board supports free exercise of religion and prohibits discrimination on the basis of religion. While students are expected to participate in all required courses and school activities, the board recognizes that at times a student or a student's parent or guardian may object to a specific classroom discussion, activity, or assigned reading. This policy is designed to provide students, parents, and guardians with a process for seeking a religious-based exemption for a student from a specific classroom discussion, activity, or assigned reading. To the extent practicable, students, parents, and guardians will be notified in advance of upcoming classroom discussions, activities, and assigned readings. Some of that is direct from statute. The student and the parent both, individually and together, or one or the other, claiming the religious-based exemption and the religious-based exemption on classroom discussions, activities, and assigned readings, that is statutory language as well. The next paragraph, a student, parent, or guardian may petition to exempt the student from participation in a specific classroom discussion activity or assigned reading that the student, parent, or guardian believes would impose a substantial burden on the student's religious beliefs or invade the student's privacy by calling attention to the student's religion. That is statutorily spelled out, as is the advance notice. Any request for exemption should be submitted to, we have a revision here because this is how we currently do it, shall be submitted to the classroom teacher and school principal in accordance with the following guidelines. So the first revision is to change superintendent or designee in the second paragraph at the end to classroom teacher and school principal.
And
school principal both.
just want to make sure
Yes. The guidelines are, 1, the request must be in writing. 2, it must specify the discussion activity or reading and explain how it would meet the 2 standards set forth above, impose a substantial burden on the student's religious beliefs, or invade the student's privacy by calling attention to the student's religion. And 3, the request may suggest a proposed alternate activity or study. No revisions in that section.
And those are not statutory requirements, that's NCSBA language, but I think it's probably a good idea. It's going to help with implementation to include those. Those the
list of
three.
Okay.
It's not statutory, just mentioned.
Ms. Mahaffey? I'm sorry, Dr. Crane, let me just pause.
Yes.
Yeah.
I just had a question on the added Part 3. Is that a requirement then that we follow, or because it's may, if the proposed alternate activity or study does not meet the statutory requirements, what authority does the district have to recognize alignment, or are we required to just blindly accept? Okay.
You don't have to do what the parent requests. The law requires an accommodation, says the local board, if a student is excused from a classroom discussion activity or assigned reading, the school shall provide the student with an alternative activity or assignment aligned with the standard course of study.
Okay.
Not necessarily the accommodation the parent specifically requests, but the NCSBA's suggestion is let's ask the parent what they're asking for, see if that, to get it on the table, and then ultimately the school decides, and you'll see later in the policy that the school's decision can be appealed pursuant to the grievance policy.
Okay, thank you for clarifying.
The paragraph below the numbered items, instead of superintendent or designee, we want to say the classroom teacher and school principal shall consult about the request, and the principal shall review it in accordance with any constitutional or statutory standards. The principal shall accommodate the request as required by law. If accommodation is not required by law, again, the principal, not the superintendent or designee, the principal may choose to accommodate such a request after weighing factors such as the interest of the child, the impact on other students, or the availability of alternative activities or materials. An appeal of the principal's decision may be made through the parent-student complaint or grievance procedure as appropriate.
The reason for that distinction, just so you know, is that there's a distinction in your policy between complaints and grievances. A complaint, a grievance is an allegation that a specific staff decision violates a specified law, rule, or policy that can be appealed to the board. A complaint, just, I don't like this, please change it. There's not necessarily a right to appeal to the board. There is a right to appeal to the superintendent or designee. So we don't know until we see the complaint from the parent whether it's a complaint or a grievance.
So can you repeat that last sentence, please, Dr. Crane?
An appeal of the principal's decision may be made through the parent-student complaint or grievance procedure as appropriate.
You want to go ahead and knock out that last?
Sure, the last section speaks about that if a student is excused from a classroom discussion activity or assigned reading, the student will be provided an alternative activity or assignment aligned with the standard course of study.
And that's the legal requirement, just to Ms. Happy's question.
Now, I know that we have these statutes, referenced at the bottom, but can you, this is a new state law, can you remind us, was it House Bill, Senate Bill?
It was in House Bill 805. It is, and it sprung into effect immediately when there was the override. So that's why we're scrambling and walking, and the last minute changes here. We've had literally about 10 days to study this.
Thank you for investing that time. Questions, board members? Dr. Ng?
Just to clarify on that sentence, and if accommodation is not required by law, and then it goes through the list. And then you, Dr. Crane, you mentioned or the availability of alternative activities or materials, but it says and. Does it matter on that sentence?
I think that Dr. Crane misread a sentence at one point. You said and instead of or instead of and. Is that what you're referring to?
Correct,
Dr. Crane?
yes.
Yes, I noticed that too. I think it was just a misreading. I can't remember where it was. Julie, but
It's if accommodation is not required by law, the principal may choose to accommodate such a request after weighing factors such as the interest of the child, the impact on other students, and the availability of alternative activities or materials.
I think you accidentally said or, but the first time you read it, that's all.
My apologies.
All right.
Thank you.
Anyone else?
I have one.
Sure.
Just to clarify, between the last two paragraphs, one is suggesting, not that I would hope that they wouldn't, that they may not need to accommodate, and then the second one is saying that they'll be assigned alternative activity. Is it conflicting, or are they just saying if they allow it, then they're going to give them something else?
It's exactly what you, it's the latter. It's what you just said, Ms.
Okay.
Caulfield. And it's not for staff to second guess. I mean, if the parent makes a good faith claim under the statute that the activity imposes a substantial burden on the student's religious belief, the teacher and the principal should evaluate that, but they should accommodate that request.
So
I think the reason we have built in an appeal process, there could be a case where someone would say that's not really a religious objection, or you're not really objecting to the specific class activity, you're objecting to the standard course of study. There could be cases that aren't things that you have to accommodate, but the statute does require them to be accommodated.
And then they would just get alternative, is what they're saying.
And to offer an alternative assignment consistent with the standard course of study, correct.
So we have what I think is a good suggestion from Mr. Hershey. Can we reference that policy with the student grievance complaint procedure?
Sure. I'll reference it by number, name, and include a link.
Ms. Rice?
Based off what was just said, in reference to if a parent makes a good faith concern about the religious belief, who's making the call about whether it's a good faith of their religion or not?
So it's in the policy would say that the request goes originally to the teacher and the principal. They're supposed to consult about it. The principal makes the decision, and if the decision is no accommodation will be offered, that can be appealed. I may have slightly overstated. This is not an automatic provision. It's not like the parent objects. Not like the library book section. That's very clear. The parent has the right to say, my child may not check this book out. It's not a reviewable decision. I do think, based on other case law, First Amendment case law, courts don't like to second guess the sincerity of religious beliefs or the centrality of religious beliefs to someone's. So I don't think this policy should lead to an inquiry about faith and beliefs in the home. It's something, I think it would have to be handled sensitively. But if the school determines, we don't believe this does impose a substantial burden on your religious belief, you're saying that, but we don't believe it. In theory, the staff could deny that request and that could be appealed. And there would be a right to appeal to the board if the parent says their legal rights are violated.
But then that's a really high bar of proof for the school to determine, especially if it's not the religion of the principal or the teacher. So even though it's like a choice that really isn't a choice, because how do you know the ins and outs of someone else's religion?
That's my point. I think Drew can speak to this. I think the practice has been not to question people's assertions of faith, but to accommodate the requests. And I don't anticipate that you're going to see a lot of, I don't believe you, responses. But we did want to build in an appeal procedure in case that does happen. You have a large district, anyone can get to the board on those concerns. Do you want to?
For that exact reason, I think, to your point, Ms. Mahaffey, overwhelmingly, I would say consistent, longstanding practice is to err on the side of the parent and the student whenever and wherever possible. And so I would hazard that almost every single day somewhere in this district, there is a parent who has expressed a concern or a student who has expressed a concern, religious or not, about an assignment or an activity. And by and large, overwhelmingly, I would say that those accommodations are made. And it's actually, I think teachers have become accustomed to building into their lesson planning different alternatives that might be available for any kind of request that comes, whether it's religious or not. So I do think that certainly the error is on the side of the parent and the family, the student. But obviously, we've got a process in place if and when the rare instance that does not happen.
Ms. Rice, did you have a follow-up?
I'll let it go.
Any other questions, board members? All right. So for 3510, can I get a motion with those changes? And we've got classroom teacher and principal appearing twice or more than twice? Principal appears more.
Yeah, principal appears more.
But with those changes that we discussed about that language, can I get a motion to put 3510 on consent on September 16th? Second. Dr. and Ms. Gordon. All right, all in favor, say aye. Aye. Any opposed? Thank you. $7602 extra duty.
Yes, we will now move into the portion of the agenda. Lots of folks may be exiting, so.
Thank you, staff, again, for being here.
This portion of the agenda addresses 4 HR policies presented for migration. And I will turn it over to Carla, Sally, and AJ, who will walk us through these. Most of these have a policy that we are replacing currently that's listed in the Tracy. I'm sure staff will reference those as well. And just a reminder that the policies that are being migrated are School Board Association model policies that in blue show revisions to reflect our practice or pieces of our old versions of the policy that we're bringing forward. Yes?
Yes, except for extra duty.
Except for extra duty, which is just us. Okay, great.
Ready?
Good
afternoon.
Yes. Good afternoon.
Okay, so again, 7602 extra duty is just a Wake County Public Schools policy. It's not migrated from school board associations. And you will see a lot of staff recommendations here for changes. The first paragraph is revised to include any employee and not just teachers. So we just wanted to clarify that. And then the last sentence of that first paragraph is just moved up from the bottom, so we just reorganized that piece. In the second paragraph, we revised that to be more clear because we wanted to make sure employees understood that if they were hired for an extra duty assignment, it was just for that season or that year, and that it would not go from year to year or season to season. So we tried to provide some clarity there in paragraph 2.
And then in paragraph 3, we removed that last sentence because we just felt like if schools were electing to do their own salary, it just would provide a lot of inconsistencies across the district. So we are recommending to strike through that and just have the standardized extra duty salary schedule for the district that's board approved.
And it's not our current practice for schools to have their own extra duty pay. We do have a published extra duty pay scale.
That was going to be my question. Thank you for anticipating that, because I didn't know if we were disrupting a regular practice. So thank you for clarifying. Ms. Rice?
If I recall, I don't know if anyone else received an email in reference to, I just want to make sure I'm not blurring lines of extra duty. What I believe that you're referencing here in policy is where it is a distinct contract or agreement for a particular job or duty. So this has nothing to do with where teachers are having to be a part of students' affairs that are on a Saturday or something of that nature, and they are the advisory person or something of that nature to, in order for students to participate, have to have that advisor there. That's something totally different. Is that accurate?
I think that actually would be part of this. I think I'm remembering the email you're talking about. So club advisors would be part of like extra duty pay. So there would be a stipend that's paid for extra duty. Now there are some times where they have only have a certain number of club positions, so it's not to say that every single club advisor in the district receives an extra duty stipend, but there are a certain allotment that schools can use to pay teachers.
And is that extra duty stipend just Monday through Friday?
It generally does include everything. I mean, we have coaches who would coach on a Saturday potentially and come in and do meeting planning. I think there are sometimes provisions where if we see that an employee is going well above and beyond what that stipend would cover, if funds are available, we can do a certain kind of additional pay. But generally, when it is an extra duty stipend, it includes that entire season or sometimes that entire year. If the person is, like a drama director, I think, is paid over multiple seasons, as is some other positions.
Okay. I just wanted to clarify. I don't know if that email or that request ever got answered or if it was clarified through this policy, but it was understood, but I just wasn't sure what they could do.
Yeah, and I think, if I'm thinking of the same one, we did reply back to that.
Okay.
Yes, ma'am.
Thank you.
I want to follow up on that. We have this program for extra duty, but then at one of our previous meetings recently, we had a policy on extracurricular duty. Can you explain the difference and distinguish those two from each other?
Back to our extracurricular.
Yeah, I've got the number here. Hold on a second, I'll pull it up for you. I believe
7405, teacher responsibilities.
Yes, yeah.
And that's what I was going to say. There are extra duties that are assigned to staff that are not in part of this policy, and they're not paid for those things. Going to the PTA meetings at night, teachers might be expected to do that and not get any additional pay. So these would be the extra duty programs where people are hired to do this extra duty above all of those other regular teacher responsibilities. So if that answers your question.
Maybe if you had some illustrative examples of what would be extra duty that would earn pay and extracurricular duties that would not.
Yeah, coaching is a huge one. And so I think there is some, go ahead.
Yeah, so that policy, I think extracurricular is a broader umbrella under which extra duty falls. So things like coaching would be an extracurricular, But that policy also references things like supervising at a sporting event or a play, acting as a, sponsor for a student club, those kinds of things. Does that help? I think extracurricular is the broader term, but there is extra duty pay schedule and positions that are a part of that.
I think I'm just trying to wrap my head around what duties outside of the regular classroom day are employees entitled to earn additional pay, and which others are part of their existing duties, even if they're outside of the regular academic day.
I think maybe yearbook is paid in Wake County. I think you get paid if you're the yearbook sponsor in Wake County. Coaching definitely is one. And that's the one where we just want to make sure coaches understand if you're hired to coach, volleyball this year or this season, you have to be rehired the next year to coach the same sport. So it's just not going on and on year after year. This policy would say that it ends and then we have to rehire. And that coincides with the other, kind of like the athletic director policy that we brought, and we're like, it has to be posted, and there was some language in there about that, posting these coaching positions and not just letting it go from year to year to year.
Kinds of duties that are regularly assigned to classroom teachers might, I'm just going to throw some things out there, might include morning duty, afternoon duty, lunch duty, game duty, like gate duty, game duty, prom, dance, supervision,
parent-teacher conferences, 74.
Parent-teacher conferences. These are all, I think, examples, not a complete list, full complete list of the kinds of duties that are assigned, that probably fall under the other duties as assigned, other duties as assigned, that are not extra duty pay.
Or pay.
Position, athletic coaching.
I know yearbook in Wake County, they're paid to do the yearbook.
There's also team lead or grade level chair. So you might have sort of a SIP committee, department chair. So the head of that committee might be an extra duty position, but other members might not be, might be extra.
Here we go. Thank you, Mr. Nieder. As pulled up for us.
I see all of your hands. I'm going to, Mr. Hershey.
I think to kind of piggyback on the chair's point, I would, and because I'm reading the policy reference 7405, and it references extracurricular activities, include such things as coaching duties. I would separate it. I mean, a coaching duty is what is the extra duty, not really extracurricular in the sense we are paying a coach, and all these other ones we are not paying for somebody to, let's see, where did I have it? Kind of some of the other responsibility. I'm sorry, I lost it in the, oh, here it is.
And you're looking at 7405?
Yeah, that's the one that Chris was referencing, that we had within the last 6 months or a year. But when you say, so it says examples of extracurricular activities include such things as coaching duties, supervising at a sporting event, concert, dance, play, or other after-school activity. The only one we pay for out of that list is coaching. And so I would remove that actually from, I don't think that's, because an extracurricular duty, isn't that kind of assigned by the principal? And I don't know if they can assign someone to coach, or if they can't. I don't know how that works.
Trying to make it mutual, right?
Right.
So maybe it makes some sense for us to revisit 7405 in light of this conversation and see if we can, if putting a distinction between extracurricular and extra duty would be helpful. We can certainly go back and do that. And I agree, like having coaching next to supervising a hallway are two very different things.
Yes.
So we can certainly look at that.
Thank you.
Okay. Dr. Ing?
Yeah, my question kind of goes in line with, before this was shown on the screen, I was wondering where the board-approved roster of extra duty positions were, and the process by which the board would approve these positions. So that was my question.
Ms. Rice? Oh, sorry, I'm sorry, go ahead.
Were you asking a question on how the board approves extra duty positions?
Well, I mean, first of all, I didn't know where that list was.
Gotcha, okay.
So,
Oh, got it.
but there
Okay,
it is.
got it, okay.
But secondly, it's a question amongst ourselves, like, how do we actually approve additional activities that may have extra duty pay?
Yeah, so you guys approve the scale. We do bring employees in particular coaching positions on the board reports as well. We have looked over the past couple of years about potentially, expanding some positions that are on this, but just one of those things that gets considered during budget development time.
Something to think about.
Ms. Rice?
Ask and answer.
Anybody else? Okay, can I get a motion for 7602 to go on consent?
So moved.
Second.
All right, all in favor?
Aye.
Any opposed? 7930, and I did make a note about the revisiting 7405, and I'll,
Is that something you want us to work in sooner rather than later, or just look at our overall schedule and try to work it in?
I will get back to you. We won't let it linger a long time, but I wouldn't want to commit the September agenda just quite yet, since with potential things that
Maybe some
we
more
have to.
overrides of vetoes as well.
Yeah,
that
but
we'll
it's,
do this quickly. Yeah.
if there's no reason, if we don't have any limitations, I'm happy for it to be back in September.
Okay, for 7930 and 7940, I do just want to say that in Human Resources, it is our mission to support teachers and employees so that they can maintain employment and, improve and get better, and we help our staff do that. We help supervisors work through that process. But in the event that someone doesn't improve, even after these measures have been put in place, we need to look at this demotion dismissal policy. And this is a migrating school board association policy. It's currently policy 3420, which in Wake County is just like one sentence. So a lot of this is new language from the school board association being migrated over. We did want to make a few changes in paragraph 1, just word choice changes to help with language alignment with other policies and things that are consistent with Wake County Public Schools. In the second paragraph, we added that from something that we have in 7940, so that the certified or professional policy and the classified policy mirror each other. So that's why that portion is added. And also to ensure that the communication is there with employees. When they're not performing at standard, we want to make sure they're being communicated with in a timely manner, that documentation is there, and that the supports are documented. Not just, what is not working, but what does that employee need to do to improve? And how are we going to help you improve? So all of those pieces are important in this policy. And then those are the only changes we made from the migrated policy.
And that's 7930.
That's 7930.
All right, board members, do you have any? Ms. Rice?
7930, second paragraph, in blue, when performance concerns arise, supervisors should communicate clearly in oral or written form. So what is the nature of documentation if it's only oral, so that we know for assurance that the employee feels that they've been properly informed, and so that the the supervisor also knows that they properly inform if it's going to be oral?
It's a continuum. So a principal or a supervisor could start out orally, and there doesn't have to be written documentation, and that employee could improve, and everything's fine. So they just had a conversation. But then, if that employee does not improve, then you need to go down the continuum and start providing things in writing, and it progresses that way. So we could put more language in here to further define those pieces, but oral might just work fine for, beginning teacher, and the supervisor meets with them to say, hey, I'd really like to see you incorporate this. The teacher does it. Everything's fine. So it could be oral at that point, just in the beginning.
Yeah, but so my concern is more of that's valid points, but we typically let's look at the opposite spectrum for employees to cover themselves if they have grievances or if they have thoughts to say, I was never told this. I was never informed this. So how do our staff get to cover themselves if everybody wants to say I did and I didn't? So I'm just looking at what's fair and impartial, and just saying that it's oral, and one person can say I did, the other person say you did not. And so how do we do a better job with tracking? I think that it's important that it's tracked, because we've had these come up before in other situations at the table. So I think we should be a little bit more concrete so that everyone on both sides feels safe and heard. What can that look like?
I think it's a great point. I don't know if it's as simple as saying oral and written form, because when we talk about performance concerns in HR, that's a serious thing. Somebody showing up a couple minutes late for the first time, where you say to the employee, hey, I need you to be here on time. That's not really a performance concern. That's where I think oral can be appropriate, where something happens one time and you just talk with the employee about it. But when we start to talk about a performance concern that is more formal, and I do think those things should be in writing. I mean, I feel comfortable adding, changing or to and, so that it is the expectation that we are communicating with employees in writing, and we do have documents for supervisors, and we make clear that when it is a performance concern, you do need to provide these things in writing. I don't know if that helps answer your question.
I think your points are very valid. I do have to ask a little bit more, and I'm not sure who understands the point I'm trying to make and can agree on what a change looks like. So we can do exactly what you just said, and either if supervisors change or remain the same, how do we know it becomes a performance issue if it's never documented at all? Because you can't just all of a sudden come to you and HR and say, well, no, it's been a problem, it happened, well, where's the proof? And so we're in a space as board members that comes to this table at the end of the day. We have to make judgment calls on things of hearsay and not proof and not data driven. And so I think we asked before with HR to, when we shared, okay, I think a policy came that we were going to change, so we're not putting in everything, we're just going to not put everything in a person's main file, but we asked, okay, well then where's your side sheet going to be, so that before it goes into their main file. And so what I'm saying, to be consistent with what we shared at this table before and what we asked for to make the best decisions about staff, to approve the superintendent's recommendations as they come, we have to have better HR practices in reference to everyone being treated fair, that you said what you said or you didn't say what you say, and not just assume that everyone is operating in good faith and good character. And it's not to say that someone is or isn't, but I think we all believe we trust, but we also verify. And so I'm just asking, what does that look like for us, if anyone else has any input? But I'm not okay with it just being oral or written, but I need for folks to have some data behind
So
what's going on.
I'll get to your other question. So would oral and written satisfy what you're looking for?
Right, I think it just needs to be documented, even if it's not going in their cumulative file. It just, somewhere in some form, it needs to be addressed, whether it's the principal's journal and the staff journal. Oh, this was just an oral, it was an oral conversation or something, whether it's just a form and sign, it's just an oral warning, that's it.
And if I'm reading this right, it doesn't dictate that it has to be a extensive document. So if we said in oral and written form, it could simply be just a document of the conversation.
Yeah, it could just be, like you said, an email to both parties, the principal or whoever, saying, hey, just confirming we spoke about such and such today.
And that is exactly what we encourage all of the supervisors to do. Even if you just had that brief conversation in the hallway, get back to your office and say, thank you for speaking with me today. Please make sure you arrive on time. Or so they could do just a quick email and it would satisfy that requirement.
Yeah, that encouragement helps, but where we're at, from where I'm sitting, that doesn't always play out. And so we come, superintendent knows, we come with real decisions because we have no documentation of anything, and it contradicts with each other down the road. So I need something that shows that there were
Real
verbal
documentation.
conversations.
Like real documentation. By the time
Yeah.
it gets up here, and that's that continuum that I was thinking about.
Because how do you track that it's a continuum if you have no proof that it's a continuum? How do you track that?
I think you have a lot of support around the table. Yes, AJ?
What if it were changing or to and, but then following up with a sentence about that, like communication being documented and maintained at the school or central services level? Would that help?
That was my point, yeah. If I can, I think the point that Ms. Rice raises, part of it is addressed if you change oral or written to oral and written. The second part of her question, if you look at the very next sentence, evaluators should provide the superintendent or designee with carefully documented evidence concerning a person's performance or conduct concerns and lack of competencies when such deficiencies have led to the recommendation and contemplation of dismissal or demotion. That sentence describes that this evidence, should be kept, should be documented, and how it should be presented. I think if we want to strengthen that, and I'd like to hear if there's any cons to this, we'd want to look at the should and making that a shall.
Yes. All right, hang on, because I don't see where you are.
It's the very,
Second
it's
paragraph.
that very
Am I
next
wrong?
sentence. Do you see 7930?
Oh, I'm on 7940, because 7940 says oral or written also.
Currently they mirror, so we
Right.
get to 7940, we can make the same changes.
Okay, all right, so let me go to, I'm sorry, just so I have it on my screen, I want to see what you're talking about, Chris.
Ask a clarifying question. So it seems like we're moving in the direction of making the policy stricter, but I'm just a little worried that there's no definition of performance concern. And I just want to tease out a couple of hypotheticals to make sure you all are really thinking you want to go in this direction. So let's say for for example, two hypothetical teachers, one's a quiet talker and one's a loud talker. And the principal walking down the hallway said they're both great teachers, excellent performance evaluations, no concerns about anything else. But one is a little quiet, kind of hard to hear. The principal said, hey, maybe you could, great job, great lesson, maybe you could just speak up a little bit. Is it a violation of policy not to send an email to that teacher because that's a performance concern? Or let's say the teacher's a little loud and can be heard next door. It's not a problem, the other teacher's not really complaining, but hey, could you just keep it down? I know you're having fun in class. Is that a performance concern that needs to be documented in writing?
If I could, to address that in the context of the policy and in the context of this sentence, it says concerning a person's performance, which you described a variation that could be a commentary on performance, But it goes on to say, or lack of competencies, et cetera, when such deficiencies have led to the recommendation and contemplation
That part.
of dismissal and demotion.
Right.
Right? So I think this only applies when conduct is leading to a recommendation of, demotion or some other action. But what we're trying to do is saying that all of this shall be carefully documented rather than should be.
Right.
Because if you leave that open, you don't have the accountability that's being talked about. We're not trying to say that any criticism has to go into a file, but anything that you say is a performance concern.
To support dismissal or demotion.
That
Yes,
needs
that
to
makes
be
sense.
documented.
That makes sense to me. That's why I wonder if maybe the emphasis should be on beefing up that second sentence as opposed to the first.
Because
you-
otherwise, it's a double-edged sword, right? To
Right.
Ms. Rice's first point, you could have a teacher that could be demoted, or we should say staff person, not even necessarily a teacher, who's demoted based on hearsay, who has had no file to go to challenge the concerns.
Right.
On the other side, if a staff member is changing positions or changes jobs frequently, they may have had many oral examples of oral feedback, but nothing that has been documented, so that when something comes up, there could be a whole pattern of behavior that's unseen because there wasn't documentation. So it can protect staff and then guarantee their due process rights, but it's also more accountability for, the situation that when we know there has been a bad action, we have documented it.
That all makes sense to me. Again, my point is just that if we just change or to and in that previous sentence, that, to me, without additional revisions, that means a principal or any supervisor is violating policy unless they immediately send an email about any performance concern, no matter how minor. And I don't think that's what I'm hearing is the intent. So I wonder if we are going to change or to and, maybe add some standard to that. If, for example, when performance concerns arise, supervisors should communicate orally and in writing the nature of the deficiencies and provide, if the performance concerns are to form the basis for a dismissal or demotion recommendation. If that's what you're saying, is you can't use it in support of dismissal or demotion unless it's been documented, then state that, or maybe some other change. Otherwise, I just worry that, again, you don't want to make it a requirement to paper a file with every minor issue that's normally addressed on a day-to-day basis in personnel.
But I guess my question with the wording would be, an incident in isolation may not be enough to be considered for demotion or termination.
Yeah.
But a pattern of many smaller would still need to be documented, or it could never arise to that level.
We should say maybe when performance concerns arise, and then put the language in for demotion dismissal when it's that serious, or when a pattern of behavior exists that could impact employment status, then we're going to do all these things. Because, that is one thing that Human Resources does anyway. We vet the documentation because we need to see it as well. So we ask for it. We ask for it first. What do you have in the observations? Does this employee have any letters? What documentation do you have to show that there are actually performance concerns? That's our first question to them if it comes up to HR. And if it doesn't come up to HR, it could be more of the oral, and they're doing things at the school, and it doesn't rise to that level that you're talking about we could put in here.
Ms. Gordon?
Yeah, I'm struggling with trying to understand. So, performance concerns, don't they need to be closely aligned with evaluation?
Yes.
And isn't it the duty of the evaluator to make sure that they are documenting in the evaluation with specific?
And that could be the written documentation that the policy refers to. It can be in the observations and evaluations. And of course, we do want the person to be told, also orally communicate with them. Don't not tell them what's happening and then just put it in their observation. There should be that oral communication along the way as well. And then the observation or evaluation could be the written documentation.
Okay, and then just one other question. Can you clearly define what a professional employee, who does that consist of?
Would be like teachers,
Right.
licensed employees.
Okay.
And the next policy is classified employees.
Okay.
So that would be your non-licensed employees.
Right, I understand that. I just wanted to make sure that I was not misunderstanding. Professional employees are those licensed educators in a school building.
I think that's the best way to define it.
Is that the title?
I think a lot of people struggle with what word to use for that.
The connotation of you're either professional or classified, I mean, I'm starting to think about what you're saying. I don't know if this is where you're headed, that we have lots of employees, regardless of whether or not they have a license, who are professional. So
Right.
do we need to kind of
Change that word.
change the title of that to, or at least put something at the very beginning to qualify what we're talking about and the definition of it?
Yes.
Yeah.
Maybe contracted employees work.
Well, the definition in 7940 of a classified position is those that do not require an instructional or administrative license. So are professional employees those that require an instructional or administrative license?
I think so.
Okay.
We're going to, I know there's a lot of talk around this one, and it's all really good discussion. If we're going to bring it back, maybe we sort of think about some different possible titles or qualifications we could add there as well.
So I actually have a suggestion for 7930 and 7940, but let me finish up these questions. Did you have anything
Yeah, no,
else?
I'm done. Thank you.
Ms. Caulfield?
It's kind of like in the line of what they were all saying, and I think Ms. Rice, I don't remember what policy she was talking to, but I know we've had this conversation before about being consistency and, I mean, being consistent. And this whole thing is about leading up to the demotion or dismissal. But I think it's important, like Ms. Rice was pointing out, that we have had this conversation before, to actually have that paper trail. That's the only thing. If we're going to bring it back, I'm fine with waiting to see what the wording comes back with. But the leading up to and having it in the file, not just leading up to dismissal. Because the idea would be that we're documenting this behavior, but also with some kind of performance outcome, the expectations we're having. So the idea of them actually putting it in is not really to slap their hand, but just to document a trail of how can we improve as well. And then if they don't improve and we come back to the file, we see that they have the consistency. And I think the concern last time was because if they do have a transfer or go to another school, you do have a paper trail that this is a real challenge for this particular employee. So that's the only thing I know we're bringing it back, so I don't need to beat up language.
Mr. Hershey and Dr. Haney?
Yeah, just very quickly, I want to give support to what the chair brought up, changing the word should to shall. And also, I think we were kind of glossing over the word concern because we were starting to throw out examples that really aren't concerns. They were like, whoa, they might not talk loud enough. Well, that's maybe not a performance concern if they're otherwise great.
That's what I'm wondering, if
And
there's
so we
a
were kind
definition
of-
or standard there, because it's not defined.
Right, and we're kind of, I think we started to talk about performance without the word concern in it when we were giving out examples as far as what should be documented. It should be a real performance concern, with the emphasis on concern, than just advice from, if Ms. Gordon is mentoring a teacher and giving some, that's not necessarily a concern, that's just, she shouldn't have to document that.
So you're saying keep performance concern.
Well, whatever the word is, I just think we were losing track of the point of this, which is about demotion and dismissal and real concerns. Real concerns, not how to help a professional employee improve.
You can bring it back with some options. I agree, Mr. Hershey. I think Mr. Haggerty's point, the thrust of the policy is is that if you're going to dismiss or demote an employee where they have due process rights, it's significantly impacting their, their legally protected interests. We need documentation, and it has to be solid. And we can beef up that language, but I think at the same time, we can make it clear it's not the board's expectation, unless you say it is, that anything that crosses a supervisor's mind has to be put in writing. Because anyone tell me if I'm wrong, but I would assume every single day supervisors give informal feedback to employees. And it may be corrective, but it's not serious enough to warrant documentation.
Right, right.
Dr. Ng?
Yes, my question is more, I guess, broad scope, but I mean, who evaluates the evaluators?
Evaluators do.
So the area superintendents would evaluate principals.
I understand, but we're also getting back to the idea of paper trail and what the evaluator of an evaluator gets. Where would you find a potential paper trail of deficiencies if there is a power dynamics that prevents people serving under that evaluator from giving honest feedback? I think we've had encounters with that in the past, and I just want to make sure that our teachers are protected as well. When it comes to having some issues that goes on in the school.
And I think there are definitely complaint processes in HR that teachers can come to. I mean, there's things like teacher working condition surveys that can kind of get to the general sense, but we do have things in place that allow for that.
And is that in a documented, written down?
Yeah, it can be a formal, we have several policies. We have the, bullying harassment policy, we have the general complaint policy. So yeah, there are policies that govern it, and we do have employees from time to time who will reach out with concerns at HR reviews.
And within those policies, those reviews would be conducted by people independent of the evaluator.
So my suggestion is that we bring 7930 and I know Chair Haggerty stepped out, but 7930 and 7940 to action on September 16th.
We're ready for that, Chair?
Well, tell me, if it's too, I was perceiving it wasn't quite, it didn't require coming back to policy.
Yeah, I think
and
we
if you
can.
think,
I think we can do it. I think we can take this feedback and make that language more evident.
Right.
In worst case, we can take it off consent and have a discussion.
No, I would not, I want it to go to action so that we can have
Oh, saying go,
discussion.
okay,
Yeah,
perfect.
because then staff can bring back the.
100% agree.
Yeah, new suggested language, no, not consent.
100%.
And if you, I think there's always the option, we can strive for action and you get your materials, and if you all see, this is not close to what we want, and you want to pull it from action and bring it back to, committee,
Right.
we can always do that, or we can take minor, suggestions at the podium as well. Comfortable doing that.
I'm just thinking of when we've done that in the past, policies that we've considered, changes and edits in action. I feel like this could be managed that way. I'm not feeling like it needs to come back here. So that's the motion that I'd like to ask for 7930 and 7940 to come to action on September 16th.
So moved.
Thank you. Ms. Gordon?
We're all in thought.
All right, all in favor?
Aye.
Any opposed? And we're going to plow through and do 7950.
Okay. So 7950 is non-career status teachers, non-renewal. So a similar vein of policy. And we are migrating this policy from School Board Association. So the blue is language that was in our current 3225 policy that sort of beefs up the protections for teachers so that the district would have to have more documentation in order to recommend non-renewal for teachers who have 5 or more years with the district. So that's why you see all of this blue. We pulled it in from the old policy. And that is to provide teachers with more of that sort of career expectation. If they have 5 or more years with our district, it provides them with that sort of assurances and protection before being dismissed. So we'd have to meet this same requirement as what's required for a career teacher, for a teacher with 5 or more years. So that's the first blue part that we added, pulled again from 3225. And then in the second part of the policy, it really is added from 3225 again, and it's our processes for granting a hearing. And so Wake County has our specific processes that we follow in order to grant an employee a hearing, and that's what's defined there in the blue. So we pulled in our practices, our current practices, into the School Board Association policy on page 2. So that's not new information, it's just combining what we currently do into the School Board Association policy.
Board members, any questions?
I'll wait.
Okay.
Yeah, go ahead.
One thing I was looking at is that right now, it's been rare that we've had the non-renewal hearings, but I think we've reviewed those as a discretionary hearing? Or has that followed an employee due process hearing?
I've not heard the term discretionary hearing for that, and I've not participated in one in Wake County, so I don't know, EJ, if you have any more information in that.
Participated in a hearing for a non-renewal.
Yeah, we had one that was scheduled.
Yes.
And the procedure I remember is that it came to the board, and the board chair and vice chair had to both independently review it and decide whether to grant it. So I thought it fell under the rules for a discretionary hearing, and I didn't know if this would kind of formalize that and replace it with a different kind of procedure, or if it would still be a discretionary
It's the same
matter.
procedure that you currently use. I just don't know about discretionary hearing. I don't know.
I don't know either. I'm seeing if I can find the answer in your policies. I'm not sure.
I just know this is the current practice. And then,
Okay.
like, if the chair and the vice chair don't agree, then it comes to hearing anyway. So all of that's outlined here on page 2.
I think I found the explanation. So in your employee grievance policy, there is a section E, process for appeals of non-grievances. It's similar to the student-parent grievance policy. And it says if an employee believes he or she was aggrieved by a decision that does not meet the definition of a grievance set forth in this policy, the employee has a right to appeal to the superintendent, and that section does have a discretionary board appeal process. So doesn't meet the criteria for an employee grievance, but this more specific policy would apply for all non-renewals, so there would be a right to a hearing.
Okay, anybody else?
See, it's in policy 1750, section E.
Oh.
Sure, go ahead.
But this policy, the revised still says the board chair and vice chair.
It says the same thing.
Yeah, so.
This says the same thing?
Yeah, it still isn't guaranteeing a hearing.
Yeah, it still says the same thing. They decide. And it.
Okay, so.
I did say right here, I did
I'm sorry,
say in my notes.
I misunderstood what you're saying.
Yeah.
This is a discretionary hearing. It's not, I misstated. It's consistent with the non-grievance section of your employee grievance policy. I guess on the theory that a non-renewal is not generally appealable.
Okay.
Sorry.
Thank you. I wanted to clear that up.
Yes.
And then just the second issue, it's not a direct change, but I see when it talks about the deadlines, it specifies calendar days. I know that there have been some issues before in generating responses within the days outlined in policy, and I didn't know if it was your evaluation at this time that we should maintain the 10 days, or if that the period that we have for response and review be reconsidered.
I believe that is I'd have to look at it.
What was the question?
I think it's part of general statute,
Is it
the
part of
10 days.
statute? Okay.
I believe it is in the non-renewal process.
That's
Um,
right.
I think that's defined for us.
Okay.
We're almost there. I'm going to let Neil check that.
Yeah.
And I'm good.
Okay.
I'll follow up with them outside.
Okay.
Yeah.
The question is whether the 10-day...
10 days is general statute.
The 10-day deadline for funding. Okay. Might not be something I can check immediately. I'm finding the answer in the statute reference, so I'm not really sure. Oh, maybe it's in 45C. I don't know the answer to that question without
Okay.
further review.
So how about this? We'll put it on consent, and then if you decide you want to pull it, we'll pull it. Ms. Gordon?
Can I just make one suggestion? And this may end up being a larger suggestion, but in reference to the last policy that we looked at, the title of professional employees, I'm back on that, AJ.
So which number, just so we're...
Policy 7930.
Okay.
And then also 7940.
Okay.
Just a suggestion, in moving away from this like non-certified versus certified, classified versus professional, may I suggest that we do professional, instructional leaders or professional employees versus educational support professionals. Because educational support professionals are classified employees. Just to keep that professionalism and level of expertise there. And that may be a broad, which we may need to look at several other policies that classify them as classified personnel. Just a slight suggestion. Changing classified personnel to education support professionals.
Okay.
You need a motion?
Yes, so the motion is, that I'm asking for is for 7950 to go on consent on September 16th.
So moved.
Second.
All right, all in favor?
Aye.
Any opposed? Okay. We are adjourned at 3:05.